Thank you for coming, and that too, perhaps straight from work, to share a few moments of thoughts with me. But let me begin by thanking the Express Group for giving me this rare honor to deliver this lecture in the memory of a great person who was an institution by himself, Ramnath Goenka ji. Tucked away in a remote corner of the country in Northeast, I regret not being able to meet Ramnath ji. But fortunately, I have not been untouched by his proud legacy. A legacy that gleams through what he had founded as an answer to Gandhiji's call to start a Swadeshi paper. Living in the realm of the Raj, it needed an iron will and an iron man, and we found it in a young Ramnath ji. His legacy also gleams through the rich jurisprudence on the freedom of the press that he was instrumental in molding, and which, by virtue of my office, I work every day. It needed a committed and a cause-driven litigant, a rarity which it is nowadays. And we found it yet again in Ramnath ji. During the dark days of the emergency, he stood as an unwavering gatekeeper of those fundamental liberties that we hold so dear today. And that is his legacy too. Today, after all these years, some remember him as the warrior of the Fourth Estate. Some remember him as a dogged, unyielding adversary. Some remember him as an iconoclast. Some as a magnificent rebel. He was at times unapologetic, at times uninhibited, and at times even contradictory. But forever he was fierce, forever feisty, and forever fearless. His entire life trajectory, from Darbhanga to Calcutta to Madras to Bombay, from the Constituent Assembly to the newsroom to the courtroom, is a test case of its own kind that we perhaps need to use more often in our lives and in our institutions. Not too long back, I had read an interesting news article talking about the surprising surge, which is not so surprising, in the sale of George Orwell's 1984 in the United States. That piqued my interest in revisiting the classic. And for some reason, I want to recollect a thought from it today, which I would like to share with you. Permit me to quote: "Freedom is the freedom to say that 2 plus 2 makes 4. If that is granted, all else follows." If I had put it very simply, for me, This is what Ramnath stood for. The freedom to say that 2 plus 2 makes 4. And that is how I remember him. Someone who could call a spade a spade. Someone who could speak truth to power. Even if it came at a cost. To be ready to break, but not to bend, could be called obstinacy by some, and determination by others. It is a matter of perspective. Is it? I do not know. I cannot say for others, but as far as I am concerned, I only feel that we need to ask ourselves some questions. Where is the Goenka in us? His ideals? His values? Is that extraordinary phenomena losing its relevance today after all these years? Why I have chosen the topic for this discourse merits a context too. And this is the context. These are some very sore questions, but too significant to get lost in the everydayness. And when it is so, what other better tribute can there be to a visionary who embodied in so many ways the spirit of a constitution than to spend a thought? To spend a thought over how far we have come to achieve the vision that he had seen as someone who had helped to free the country in one era and help it to become a meaningful democracy in another. I'll use a few minutes to put across my proposition as to what I intend to say when I talk about the vision of justice. I'll borrow from the chief editor, Rajkamal Jha himself, because it offers a very fine perspective, very powerfully, very thoughtfully, and very rightly. Jha had said of Ramnath in one of his letters to me, we had exchanged some correspondence relating to the subject. And he said, fierce independence and enduring sense of inquiry without fear or favor were the two values that Ramnath believed formed the bedrock of justice. It is absolutely incontestable that they do. And for convenience, let me call them the bedrock principles. But if I were to look at it anatomically, while these do indeed form the bedrock of justice, what is the form, what is the body of the ideal called justice, which rests on this bedrock? The bedrock principles have been the talk of the town lately, considering how the entire think tank is so keenly focused on it. I am not suggesting that it ought not to be. It ought to be done, and it is being done. I cannot recall the last time the judicial wing of the state made so much news. On a lighter note, the American founding father, Hamilton, who had suggested that the judiciary was the least dangerous branch of the three branches. And I'll refer to him again during the course of my address. But were he to be here today, I wonder if he would have felt the same way. More so, in the light of the Indian Express top 100 most powerful Indians, which included several names from the judiciary. But the fact of the matter is, that if we have to take stock, take stock of how we have fared. And about 7 decades later, since we have ventured into becoming a constitutional order, this appears to be an opportune time to do so. We might as well do it comprehensively. And by comprehensively, what I mean is that we must evaluate both the bedrock principles and the form principles, because the vision of justice, the way I understand, is a compound of both. Clearly, they are not unconnected. And over the course of the next about 20-25 minutes, I'll attempt to touch upon both. I'll begin with the form principles, and bear with me, in order to drive home my point, I may have to get somewhat academic. You'll agree that in the backdrop of a bleeding mega partition, deeply entrenched inequities, perpetuating injustices, our Constitution ushered us into believing in a grand promise of transformation on a scale that was beyond reformatory. It was, in all its full glory, a revolution in all aspects of life, social, political, and economic. In a way, it said, let bygones be, and a new society that we would be egalitarian, while preserving our pluralistic character. We would be democratic and united too. The state would be religion neutral, the citizens equal and together. Coming to think of it, it was just as pretentious as it was unpretentious an idea. But be that as it may, public institutions, one of them being the judiciary, were inherited. They were tweaked where the need was felt to give life to this prodigious architecture of justice. And here I would like to clarify that by justice, I am not implying only the juridical connotation of the word, which is the administration of justice by the courts of law, although it is just as imperative. But justice is something that is an overarching principle, an underlying fundamental, the spirit. In order to say, which is why I say prodigious, because it was a confluence of many philosophies. Firstly, the Aristotelian, for instance, which suggests that the very essence of the state is justice, which according to the philosopher was a social virtue, good of others, equality, and fairness. When we peruse the preamble to the Constitution, our vision document, is it not that this ideology is enshrined in the words equality of status and opportunity? Or the utilitarian philosophy of John Stuart Mill, whose view was that justice was the greatest good to the greatest numbers. In the preamble, is this not enshrined in the principles of socialism and equality yet again? Or the relatively more modern one, the Rawlsian perspective, which is that justice as fairness is the most egalitarian and also the most plausible concept of liberalism. In the preamble, is this not reflected in the words liberty of thought, expression, and belief? So the preamble, if we deconstruct it precept-wise, is the very embodiment of these ideas. Justice is not something that is a standalone precept, but an amalgam of other ideals like socialism, democracy, liberty, equality, fraternity, to name a few. They are not isolated silos, because their undying endeavor is to establish one discipline of overall justice of an inclusive society. And this is exactly what I meant by the form principles of justice as an ideal. As a composite unit called justice, this had been intended to be achieved by the legislature, the executive, and the judiciary. Now, it will make for an incredibly interesting, and if I may add, overwhelmingly contentious tale to tell how the executive and the legislature have performed on this front. But the scope of my discourse will be limited to the judiciary's endeavors in this regard. A few months back, I had the occasion to deliver the Justice P.D. Desai Memorial Lecture at Ahmedabad. And there I had proposed that attaining constitutional idealism, which Mr. Jha had mentioned, was not like chasing a rainbow. And the Supreme Court, through its pronouncements, had been reflecting it. It would not be a display of any pessimism of the intellect. If today I were to say that while indeed attaining constitutional idealism is not like chasing a rainbow, but it is so only in the courtrooms. Perhaps because the fields are where rainbows are. The point being that the way the nation is built and the way this grand vision of justice is attained in the confines of courts through judicial pronouncements and the way they are built on the ground are two very disparate realities. Agreed. The aspirational aspect of the Constitution and the operational aspect of the Constitution will always be two different notions. The aspirational aspect is high idealism of a kind that is almost moralistic and preachy. The operational aspect has to do with the very strange realities on the ground, almost defeating. But then, even if we may be slow to move to bridge the gap between the two, which itself is not an acceptable compromise, but we must at least not become retrograde. Take, for example, the Supreme Court's 2015 ruling in Shreya Singhal. It is a celebrated judgment, where the Supreme Court held the public's right to know was directly affected by Section 66A of the Information Technology Act. Interestingly, while doing so, the court was certainly inspired by, amongst others, rulings, Ramesh Thapa, Brij Bhushan, Bennett Coleman. If you would recall, these were perhaps some of the earliest pronouncements protecting an independent Indian's speech and expression, and were delivered in the light of the rights of the press, which verdict themselves had endorsed that a democracy was a marketplace of ideas where the people had a right to know, that prior restraints were anathematic to a democracy, and that the foundation of speech and the press is the ark of the covenant of democracy. Shreya Singhal took this legacy ahead, as it improved upon the jurisprudence on the independence of the press to attain and promote the constitutional precept of plurality of thought, diversity of opinion, and the ethos of democracy in the technical age and in the context of online speech. The vision of justice was indeed attained in the courtroom, not once, but multiple times. I ask myself, has it translated into reality? Has the success of these strong verdicts reached the ground? I will let the facts speak for themselves. On the ground, it appears to be a descent into chaos. And it is worrisome on all counts. When you sue the messenger, or you shoot the messenger, or when the messenger himself declined to deliver the message because of the fear psychosis. On 19th of June of this year, the Indian Express had published a very insightful article. This was selected from The Economist, titled as How Democracy Dies. It said at one place, independent judges and noisy journalists are democracy's first line of defense. Reports of the death of democracy are greatly exaggerated. I'm quoting from Indian Express. But the least bad system of government ever devised is in trouble. It needs defenders. I agree. But I have a suggestion, a slight modification in today's context. Not only independent judges and noisy journalists, but even independent journalists and sometimes noisy judges. While Shreya Singhal was significant in its own right, Nalsa versus Union of India, the transgender case, breathed new life in the equality principle. The court understood that our founding fathers' vision about fundamental right against sex discrimination was to prevent differential treatment as a result of one's not conforming to generalizations. The judgment made a momentous foray into the fountainhead of dynamism. I'll come back to it, but before I do that, I must touch upon a very fascinating judgment of 1986 vintage. You all know about it. Bijo Emmanuel versus State of Kerala. This was a case where 3 Jehovah's Witnesses had refused to sing the national anthem when it was being sung in their school. They did stand up though. Nevertheless, they were expelled from the school. When the case found its way to the Supreme Court, while holding that the expulsion would be in violation of their fundamental right to freedom of conscience, the court observed that, I quote, the real test of a true democracy is the ability of even an insignificant minority to find its identity under the country's constitution. The court also felt the need to add a thought, and I feel compelled to quote it. It is the penultimate line of the verdict, and it says, I quote, our tradition, thank you, teaches tolerance. Our philosophy preaches tolerance. Our constitution practices tolerance. Let us not dilute it. Recently, in Adi Saiva versus State of Tamil Nadu, this was sometime in 2016-17, the Supreme Court held that even in matters of religious beliefs, constitutional legitimacy cannot be forgotten. And following the great Justice B.K. Mukherjee in Shirur Mat of 1954 vintage, the court went on to hold that it is not the state or the religious Indian, but it is the constitutional court which decides on what constitutes essential practices of any particular religion. Some of you could be wondering, how these judgments are even related. They are not, but they are at the same time. This similarity is that the first one originates in a very intimate, private sphere of life, and the other two originate in what everybody seems to want to have a say in, the matter of fate. But it is the similarity that should be the takeaway. The judgments beyond their bare letter say that societal morality is fickle, and not societal morality, but it is constitutional morality that ought to dictate terms. As an Israeli judge, Aaron Barak, points out, it is not the transient spirits of time, but the fundamental values that should be the guiding voice. In his last address to the Constituent Assembly, Dr. Ambedkar had said that we must not only be a political democracy, but a social democracy, as the former cannot last unless lies at the base of it the latter. And social democracy he defined as a way of life which recognizes liberty, equality, fraternity as one principle. I wouldn't want to wade into knowing if we are a successful political democracy, but I do honestly believe that we are a social democracy in all respects. And the disparity is there because the two Indias, both just as perceptible, are in conflict. There is an India that believes that it is the new order, and there is an India that lives behind a ridiculously drawn poverty line, on daily wages, in night shelters, with no access to education or healthcare, let alone access to courts. The ambivalence is intriguing, and this is exactly what I call as getting lost in transition. One India, in the above-mentioned perspective, is the vision, and to know how far we have succeeded in attaining this vision of justice is really a matter of perception. But nevertheless, there is a graphic disparity right there, and removing this disparity will be the mission for the Indian judiciary in times to come. And I may add that for that to happen, it is going to require a constitutional moment of its own kind in the life of this institution, which I believe has been long overdue. The constitutional history with reference to this institution as a whole, and especially the Supreme Court, would show that its own roles have constantly evolved in the light of the socio-political context. In the 1970s and 80s, it was a decade where the Supreme Court expounded the basic structure doctrine. In the 80s, it constantly expanded the scope of Article 21. And by the 1990s, it became somewhat of a good governance court by innovatively interpreting constitutional provisions to address the inadequacies consequent upon executive and legislative inactivity. In the first 50 years since our independence, the Supreme Court has created a very sound jurisprudence, which we continue to reap from. It is the inertia, really, that has kept us going till now. But the way things stand today, court processes are a trial, even before the trial has begun. While I cannot say if it is a collective failure on our part, but for a nation governed by the rule of law, is it not a matter of concern that to this extent, at least, we are defying the idea of inclusiveness? Not a reform, but a revolution is what it needs to be able to meet the challenges on the ground and keep this institution serviceable for a common man and keep it relevant for the nation. For the effectiveness of the judgments to show, the justice dispensation system has to be made more result-oriented, namely to say, more focused on enforcement. I understand what Mr. Arun Suri, he is not present today, had suggested when he wonders if the judiciary is not being an accessory to the resulting deterioration, which in its hopefulness and optimism doesn't go after its mandate till its implementation. We give it up halfway. I find it difficult to agree with Mr. Suri and his proposition wholeheartedly. But I will certainly say that the judiciary must be more proactive and more on the front foot. This is what I would call as redefining its role as an institution in the matter of enforcement and the efficacy of the spirit of its dictates, of course, subject to constitutional morality. Here, separation of powers. I'll even go ahead to say that the institution at all levels needs to be more dynamic in a matter of interpretation of laws. And this is what I mean to say by a constitutional moment of its own kind. However, it is going to be a tall order, both at the micro level and the macro level, because both come with their unique sets of challenges. By micro level, what I mean is the administration of justice on a day-to-day basis. Here, the so-called inefficiency and slow processes in the judiciary have been historical challenges. I'll put it very simply. The judiciary today is not a poor workman who blames his tools. It is a workman with no tools. I'm not going to keep you busy with the figures that we keep consuming every day on pendency, areas, judges' strength, etc. But in the light of what a French author had once said, I quote, "Everything has been said already, but as no one listens, we must begin again." I will only ask and request those at the helm to finally listen so that we must not have to begin again. In addition to that, I also feel that there is a pressing need to explore the endless limits of legal services mechanism. Legal awareness and legal empowerment of the marginalized in this vastly unequal society of ours have to be made an observable reality. Let me give you one instance which is glaring insofar as personal liberty is concerned. 67% of the prison population in India are under trials, most belonging to the absolutely underprivileged classes. 47 of the 67% are between the age group of 80 to 30. Compare this with the UK, where the percentage is 7. And the US, which is acknowledged to have a high rate of incarceration, the percentage there is 22. The period of about 1 year that a majority of the under trials have been in custody would hardly redeem the situation. Will it be wrong to suggest that a fair share of a demographic dividend is being unjustifiably lodged in jails, and mostly for petty or less serious offenses. I call the young population of India 18 to 30, which constitutes more than 50% of the population, as our demographic dividend. They are an asset. At the macro level, the judiciary as an institution is being seen as a course corrector, a leveler, a democratizer of sorts. And since it is too well known that our country is on the cusp of an evolution, naturally, it will have implications for the judiciary as an institution also. I would like you to recall that I had mentioned about Hamilton in the beginning of the discourse. While contemplating the US Constitution, he had said, the judiciary is the weakest of the three branches because it neither has the force of the executive nor the will of the legislature, but only judgments. This, and which I agree, he said, was the simple view of the matter. Correct. But there is a complex view also. The complex view is this. And this is something that Hamilton was envisaged and foresaw 2 centuries ago. He had said that while civil liberties will have nothing to fear from the judiciary alone, they will have everything to fear from the union of the judiciary with either of the 2 branches. I would like to believe this is why Ramnath ji had also said that fierce independence is indeed the bedrock of justice. But I'd like to add that independence must always be responsible with due regard to established constitutional values. This institution, the judiciary, is the last bastion of hope and the one that the citizenry believes firmly will give justice to them, come what may. And it has. The judiciary, with whatever little it has at its hand, has been a proud guardian of the great constitutional vision. It fills me with immense pride to see that an institution, as an institution, the judiciary has been endowed with the greatest societal trust. This fact gives it credibility, and this very credibility gives it legitimacy. It is a very enviable spot for an institution. I'll only say that if it wishes to preserve its moral and institutional leverage, the judiciary must remain uncontaminated and independent and fierce and at all times. A chain is only as strong as its weakest link. So is an institution. And if introspection is where we have to begin, we might as well begin there. Perhaps we can hope and endeavor that in the future, it is not our finality, but our infallibility that should define us. It is my imagination of an ideal world, and I am aware of what Carl Jung has said of it. He said, I quote, "Every form of addiction is bad, no matter whether narcotic be alcohol, morphine, or idealism. I don't know how true his views are on alcohol and morphine. But as far as idealism is concerned, I would say it should be pursued like an axiom. Ladies and gentlemen, thank you for your patience. Jai Hind.